um, let me make sure I've got the right forms open here.
This is not a form that's being updated, is it?
It is not. No, it was not one of the ones that was being updated. All right, so exclusive right to buy, buyer agency agreement. Let me pull that up for you guys to see, and we'll go through, and it'll trigger some other good discussions on it. All right, so you should now see the buyer agency agreement. Everyone see that? Perfect. So again, we're going to use this as a format to go through and see what kind of questions come up and what will come from it, and then also kind of other things that have happened. This will trigger some things that have happened for you guys for us to talk about, just to kind of put in the back in your filing cabinet, so you'll know kind of how to deal with it should it come up. So first part of this, pretty self-explanatory. Contracts between the actual buyer as well as the broker, the brokerage. So it would be the specific brokerage of which you remember. So Keller Williams, Charleston West Ashley, Mount Pleasant, Isle Palms, or Key. It is signed by you, however. The purpose of this agency. So the reason I do say that this is important to spend some time on this is in the event you do have someone, it's a little bit of a tricky situation because you can't really have an exclusive right to buy agency agreement with two agents. However, you could have an agent that's exclusively representing you, say if they're looking at Myrtle Beach versus Charleston versus Hilton Head. So in the event that someone says, well, I'm going to be working with someone down in Hilton Head as well, then you could put here general description, Charleston MLS or Charleston area, then that way they could feel a little more comfortable with it. But you don't want to also then limit yourself to where if you put, West Ashley, then all of a sudden they're thinking, well, they need someone else to represent them should they work in any other area. And then Charleston MLS. Other than that, if you could fill in the general terms of this, price range, that sort of thing, but just be careful you don't limit yourself to quote unquote knock yourself out of the agency agreement should they find a property that's outside of these terms. I like walking through the paragraphs as far as the broker's duties, because this kind of allows us to talk about how to talk about this with the buyer as we're going through it. So A, the broker shall provide the buyer meaningful explanation of agency and shall use the broker's professional real estate knowledge and skills to represent the buyer in a diligent and effective manner. So this is the first part, obviously, where it's saying, don't forget, you need to be giving them the agency disclosure before having gone and done this. So if you are going through the agency agreement now and you haven't done it, this would be a good time to refresh them to make sure they understand the different levels of agency and that they've confirmed that this is the type of agency they want to have. They want you to represent them as an exclusive agent. B, if the broker is not representing the seller, the broker shall represent solely the interest of the buyer in all negotiations and transactions regarding the acquisition of real property, and repudiate any agency or sub-agency relationship with the seller or the company representing the seller. Shall not claim the sub-agency compensation offered to the selling broker in the multiple listing service. So basically what this is saying is that you are only working for the seller, and as long as the buyer, and as long as they are, you are currently not representing the seller, or Keller Williams is not, you will be working as a sole exclusive agent on this. The sub-agent part on this is a little dated because there's no sub-agency in South Carolina anymore. So this will probably be one of the updated forms over the next, it's not on the chopping block this year, but probably will come up there soon. Anytime it says sub-agency, really that's now transaction brokerage. So just something to keep in mind. Now, this is where you get into kind of the description of what it would look like should you get into either one of the types of dual agency. If the broker represents the seller as well as the buyer, i.e. disclosed dual agency or designated agency, the broker shall not disclose to the buyer information obtained within the confidentiality and trust of the fiduciary responsible relationship with the seller, nor disclose to the seller information similarly obtained from the buyer without the consent of the party adversely affected of the disclosure. So this is where you would say, if let's just say you're in a situation where you are presenting this to a buyer who's interested in a listing that you have, right? This is it's a potential dual agent situation. This is where you would specifically map out to say, here's where we do need to disclose with you kind of where there may be a conflict. and how we protect you from that conflict. So Mr. Buyer, if in this situation, I do represent the seller, or you could say if you're entering into dual designated agency, you could see the same. I am not able to disclose to you any information that was obtained from the seller. Now, in a designated agency situation, that wouldn't be an issue because you don't have that, right? You don't have that relationship with the seller. But Mr. Buyer, I'm also not allowed to disclose to the seller anything that would adversely affect you. So this is just something that we, you are protected by the contract here in the event you're concerned that there be any sort of quote unquote lack of representation. Again, you don't have to choose to be in an agency relationship with me. Should you choose to do so though, this is where you're protected. And then the last part, this is an important part, particularly in this market. The broker may represent other buyers who may be interested in the same property as this current buyer. This is something that you have disclosed in this specific paragraph. I've gotten this question a couple of times over the last couple of weeks: is this the only time we should disclose? Where this came up recently, we had an agent in the West Ashley office who was in a multiple offer situation, and he was representing two of the buyers in the same situation. And he had technically already, he was not representing the seller. He had two separate buyers. Both buyers were putting an offer on a listing. Well, per this agreement, he had already disclosed the potential, right, that he could be representing two buyers interested in the same property. So he asked if he should, if that was enough. And my advice was, hey, it would never hurt to disclose it again, right? And it doesn't have to be super dramatic, Celeste, just so you know, I'm also representing so-and-so. No, it just say, I want to make sure that I'm clear with you, as we talked about in the buyer agency agreement. In this situation, I do represent one of the other buyers that are on there. However, that does not mean, obviously, in this case, it really doesn't affect you as much, because obviously I wouldn't want one to win over the other. I want both of you to win, so I'm going to be as aggressive for both of you. It won't hurt to disclose it again, is the point on that. Upon termination of this agreement, just finishing up this paragraph, or completion of this agreement, broker shall keep confidential all information received during the course of the agreement, which is made confidential by written request or instructions from the client. In this is just more of a reminder for us to make sure that you do need to keep all files on record, per South Carolina law. Obviously, having it in the DocuSign system or in the opportunities, you will keep it the required period of time. Should you have physical copies of this is total side note. Should you have physical copies of any of your contracts that would have personal information on there and you are going to throw them away, please shred them. That responsibility could come back to you should that information get out. Then the last part just basically is another disclaimer that the broker represents the brokers that we're duly licensed under the laws of South Carolina as a real estate broker. We use our best interests of the buyer's agent to locate property and type as described in the section above, and to negotiate acceptance of any offer to the buyer, purchase, lease such property. During the time of this contract, broker will give buyer information describing and identifying properties that appear to broker to substantially meet the conditions as set forth in section 2, which again, by the way, this does bring something up. If they have set some pretty standard or pretty strict guidelines up here, or just in general, this isn't a buyer agent or a buyer consultation class, don't be sending property to buyers that are outside what they've asked for. Now, you can have a buffer, right? They're looking up to 300 and you send up to 325. Okay, and explain to them why you're doing it. Get a lot of times, interestingly enough, when if things go to complaint with buyers agents, it's like, well, from the beginning, she was just sending me, properties that weren't relevant. I told her I wanted 4 bedrooms and she sent me 2 or 3 that were 3 bedrooms. Okay, well, that's not a huge deal, but if you are sending things outside of the scope of what they're being asked for, you want to make sure you communicate to them why you're doing that. Okay. Section 4, this is also a good, in my opinion, this is a good section to be familiar with, because this helps you in the kind of the expectations dialogue, right? So when you have your buyer consultation, Mr. Buyer, these are the duties that you have. This is the expectations I would have for you in this. You can word it however you like. First is to work exclusively with me or any of my affiliates should I be out of town, right? So viewing any property only with the broker. If there is a chance that you would need to see it outside of that, we'll cover that a little. Or if I'm not available and there's extenuating circumstances, we'll cover that. But not with any other real estate brokers or salesperson. You'll exclusively allow me to identify the property. This one obviously comes from this. However, should you find something, right, outside of what I find you, please let me know, which leads to part 3. Referring to the broker, all inquiries received in any form from any other real estate broker affiliated licensees. And this last part, well, let me come back on that a little bit. That also is, you know, should you have brokers following up with you? Like, let's say if you go visit an open house, or you go, you happen to stop by a listing because someone was in the driveway, just let me know that you've spoken to them so I can start that communication. So in the event you are interested in that property, we don't get any lines of communication crossed. And then if they do follow up with you, just let me know. So they're kind of the three first ones here. Now, I would say going to number 2, you can say, obviously, and I said this earlier, excuse me, obviously, Mr. Buyer, should you come across a property, which you will, you'll see something on Zillow, somebody will post something on Facebook. If you haven't received that from me, it's, you know, it's either wasn't in the search, or for whatever reason it slipped through, just let me know. The chances of that happening are slim to none. A lot of times right now, everybody's looking for properties anywhere, and they're just getting the information to you as soon as possible. So parts 4 and 5, the reason I'm going to spend a little bit of time on this is because we have had some buyers push back on this part of it, which is holding the broker harmless for liability as a result of incomplete or inaccurate information provided to the broker by the buyer or seller, and holding the broker harmless from liability as a result of the seller's failure to provide a complete seller's property disclosure condition statement. And lastly, identifying the broker against claims, damages, losses, expenses, or liability arising from handling of earnest money by anyone other than the broker. The reason I bring this up is we've had a handful of situations that have come up where, well, 2 situations. One, where buyers have looked at this and they look at it and it comes up again later, which we'll talk about. And they've also looked at it on the listing agreement and said, hey, I'm not going to sign this. It says if you mess up, I can't hold you harmless. We've had our lawyer look at this, and the lawyer said, listen, if the buyer's really adamant on that part being crossed out, that's not something that our lawyer thinks would be very important to argue against. You know, if at the end of the day, a hold harmless written in here is not probably going to protect us as much as we would want it to anyway. And he personally doesn't feel, or professionally doesn't feel, that it's worth pushing back saying, no, you have to sign this part of the document. So if that does come up, this is kind of your blanket of, if they want to cross it out, that's not the hill I'd die on if I'm trying to, you know, win a client in this situation. I would throw a red flag though. Or no, not a red flag, a yellow flag. Just a, you know, caution that you may be dealing with someone who may be a little more particular in certain situations. So let's give me 1 second. We'll wrap this one up. We'll come back to that. The other thing is, excuse me, what this brings up is the seller's property disclosure, which is specifically referenced in here. By having that filled out per statutes in South Carolina law, real estate law, is that does protect the brokers. So if that is filled out, the brokers are protected should something come up that was not covered in there. Now, the reason I say that, a little bit of a side note, it's not a seller class, it's a buyer class, but this is why it is required for the seller to fill this out. The exemption form, a lot of people say, well, we're going to exempt it because the buyer and seller agree that they won't fill it out. No, the exemption is only if they actually qualify for the exemption in there. They do need to fill out the property disclosure statement. Celeste, you got a question?
You covered it. That's what I was going to ask, is if the seller disclosure would kind of take the place of this. So
it does, and I'll be honest with you. I did not realize, full disclosure, how much of a protection that was, because we had a lot of sellers that are just looking at that seller's disclosure saying, look, we're not going to fill it out. And if you look, you know, on page one of the pages of the contract, it says it either is included or it is not included. Or will be filled out or will not be filled out. And if they opt for it not to be filled out, the brokers lose protection. Now, I understand that the contracts are not here for the brokers. I do understand that. However, we do have contracts that were created and presented by a state advocacy association, right? That do help protect us in these situations. So that's why it is important that we do have our standard property disclosure should be filled out unless they are truly exempt based on the reasons that they've acquired it by a court order. You know, never having lived in the house is not one of them, right? You know, never, or haven't lived in the house in years isn't one of them, right? It's literally if it was a bank that acquired it, and honestly, anytime it was acquired by some sort of court document, they could be exempt at that point. That covers probate, that covers foreclosure, that could cover any sort of having to take over for any sort of mental capacity issue or anything like that. But that's just something to keep in mind, that is, we don't really take that into consideration, that if the property disclosure is not filled out and then something goes awry and there was a disclosure issue on the property, the agents have one less layer of protection. Let's make sure we word that accordingly too. It's not like they're fully protected if it is filled out, because let's be honest, if people are going to sue, people are going to sue. It's just one less layer that the brokers have.
So Joseph,
All right, so yes, ma'am.
what happens when when they fill out on a property disclosure, no representation, like all the way down?
That's fine. That's their right to do so, right? Their right is to fill it out, but they have been given the opportunity, right? And then they have stated, we've looked at this and we have no representation. And then honestly, let's just say worst case scenario, which is what we all like to paint the picture on, right? So let's say worst case scenario, fast forward and your seller represented no representation all the way down. 6 months later, the house floods in the kitchen. They call a contractor comes out there and is like, oh yeah, I came and worked on this house, a year and a half ago. And this problem was, I told them it was going to be a long-term problem. Well, now all of a sudden you've got a non-disclosure. Now, granted, in that case, the seller could have absolutely forgot. There may have been no ill intent at all, which is 9 times out of 10 what it is. But at least at that point, they were given the opportunity to do it. And that just creates that layer of protection for you.
Okay.
Hey, Joseph, can I ask you one thing real quick?
Of course.
In the very first beginning of the contract, where you put in the broker being Keller Williams, and you said don't put in Keller Williams, Charleston West Ashley. I haven't thought about that, and it made good sense. I've been doing that. I won't moving forward. So we can just put Keller Williams Charleston, and that covers all the branches, I guess.
No, you will want to be specific on. I mean, again, it's important. Properly done would be Keller Williams Charleston West Ashley, Keller Williams Charleston Mount Pleasant, Keller Williams Charleston Islands, or Keller Williams Key. Like, it would be important to put that in there. Yes, it's a default on the side of putting specifically in there what it is. Because, and the reason behind that, Mike, is this all comes into this whole disclosure of names, specifically names of specific locations, and where the LLR and the association's cracking down. And I get it. It's a little silly, but I get it. Is the consumer's ability to identify who to go to if they're upset with you, right? So Mike does something wrong. I need to go figure out who I'm supposed to contact with Mike. And I go Google Keller Williams Charleston, or just Keller Williams in the Charleston area. If I don't have any more specific information, it's hard to determine who that is. Now, quite honestly, for Charleston, it's a little easier because we do have the relationship with the broker between the offices. However, from the state standpoint, they look at all 4 of them as completely separate entities.
I'm glad you recovered it, because I definitely misunderstood the first time. Thank you.
Nope. Yeah, absolutely, man. All right, so second part of section 4, assist the broker and its affiliated license in the process of identifying, negotiating, and contracting to purchase, lease, or otherwise acquire by providing the broker reliable information, including financial information and written authorization to obtain verification of funds the broker deems necessary for the performance of this agreement. By the way, this is something that you might want to explain if you know you have a cash buyer. Again, this never was something you think of until something goes wrong. We currently have a situation. Fast forward, the property closed a couple months ago. Buyer's upset with how a lot of things were handled. One of their complaints is that the buyer's agent was insistent on getting proof of funds, and they felt that was inappropriate. And personally, I think it's a silly argument on the buyer's side. I don't know what contract would, what transaction all cash would not want proof of funds. However, what this is telling me is that our agent didn't properly explain to this cash buyer up front, we will need to provide proof of funds. And this is the part of the contract which says that you will participate in that. Now, I don't need a bank account stating that you have tens of millions of dollars. I need some sort of proof stating on some sort of official document, letter from a bank, whatever it may be, stating that you can afford the property. Number two is making the buyer themselves available to meet with the broker to see properties in order that the broker will be able to perform the promises of this brokerage engagement. Obviously, Mr. and Mrs. Buyer in this market, that may be a little difficult, right? And there are times now where we have got buyers that want, are wanting to put offers sight unseen, and there's nothing wrong with that. It is risky though. And if you do have a buyer that wants to purchase a property sight unseen, I would not advise them moving forward with anything other than a due diligence contract in that situation. Now, we all know that many sellers are not accepting due diligence right now. They only want repair addendum, on a gold-plated contract that's going to close in 3 days with no issues whatsoever. However, if you do have a buyer that can't see the property, you want to make sure that you've disclosed to them that their right and privileges to see the property prior to going out, and that should they need to move forward with repair procedure, that they can't get out if they just don't like the house. We've had a couple incidences of that. Well, here's one. I'll pause this one for you, Celeste, because you asked. We had one. We had one a couple weeks ago, a very high-end property, sight unseen. There were only exterior pictures of the property on the MLS. Very desirable neighborhood, very desirable home. Buyer absolutely wanted it. Agent wasn't able to get to the house in time to even do any sort of preview. They were like, whatever, we'll put it in. They actually did due diligence, which was fine, but they had a due diligence termination fee of quite a bit of money. And then the seller, the agent finally got to go to the house after they ratified the contract and FaceTime through the house, and they hated it. Absolutely hated it, everything about it. And luckily, the buyer's agent had done a very good job explaining, hey, there's a risk if you've never seen a property. Even you haven't seen it. It can be pretty in the pictures. In this case, that was a moot point because they didn't have interior pictures. And I know it's an emotional market, and I know you want to move fast, but there is a risk in this, and that it cost the buyer quite a bit of money to get out of the contract because they had a termination fee. So just make sure you're fully disclosing the risk that the buyer has in all of these situations. Okay?
So Joseph, the seller actually put in that high figure and they accepted it?
The buyer came in with the high figure to win the offer.
Hey, that's probably not wise. That high.
There are a lot of things that I was like, what were you thinking? But our agent explained everything to them. And they still wanted to do it, and they knew it. And here's the deal. This all comes down to communication, right? The relationship you have. Well, most of the time, it was a very broad brush statement. Sometimes you can communicate wonderfully and the buyers will still turn on you. But for the most part, if you communicate well and you're open with them, in that case, they were able to work it out. So.
Well, just curious, has that particular person lost a lot of deals that they were willing to do that? This seems like
in that case, they were, because they were very specific on the neighborhood they wanted to be in. And specifically, it was in Ion, and it was specifically one of the waterfront homes in there. It was, yeah.
So is there a reason why they didn't have interior pictures in the house?
It had just come on the market. They just hadn't, they got it on there. It was a fun situation.
Yeah.
Now, in that situation, it was worked out where the seller opted to release them without the full option, because it was within a couple days. Again, it all comes down to communication, right? There's, at the end of the day, if it's not in the four corners of the contract, we can't do anything about it unless we have a good working relationship where we can call Patty up and say, Patty, look, we got a situation. Here's what happened. And I know what the contract says. Can we work something out on this to where we make everybody, whole on this? You've only been off the market for 24 hours. We understand that we don't have a dog in this fight when it comes to the actual contract. Can you talk to your client about having any wiggle room? That's what happened yesterday with this one, where the buyer and seller finally were just like, yeah, now that, high emotions have come down and, smoother has prevailed, that's typically what you can have happen. All right, last part of what the buyer is to do, the last two sections are provide the broker and affiliate general nature, location requirements of what they're looking for, price range and other terms, and the conditions of a desired property, and then authorize the buyer's attorney, who they will use to furnish the broker copies of the final settlement statement, which basically is just saying, hey, when this all closes, I will have a copy of the final settlement statement on there, and this is a disclosure that I'm doing. So. All right, so section 5, this one talks about the compensation of the buyer's agents. And this one's getting kind of interesting in a couple of different ways. So there are two types. First is the brokerage fee. This is 90% of all of this is going to come from one or two. Probably 95% of all of your compensation agreements are going to be option 1 or option 2 under A. Option 1 basically says that I'm going to get a brokerage fee, which is the greater of either this amount or this percent from the purchase, either from the listing agent, or if the listing agent isn't offering me this percent, then you, Mr. Buyer, will make up the difference, right? So what this is saying is if I'm working with Sarah, and Sarah's my buyer, I'm gonna say, Sarah, here's how I work. I get paid at least 3% on a transaction, right? So in working with me, if we go out in the event that a listing agent is offering out 2.5%, then you will agree to cover up the additional 0.5%. So I will get full 3% on it. Okay, nothing wrong with this. You're absolutely welcome to do this should you want to. It's all about the value you're providing to your buyers. Here's where this is causing some heartburn right now. If you do have option 1 selected, then you do put yourself in a situation where it will cost your buyer more to buy house offering 2.5%, house offering 3%, all other things the same. Okay, hold on one second. I'm not saying good, bad, or indifferent. I'm just telling you this is a reality of that situation that you now are in with your buyer. So if you are showing property, you can go out and then you can say to the agent, I can call Mike up and say, Mike, hey, I've got a buyer that's interested in 123 Main. I am going to be showing it. However, you're offering 2.5%. My buyer has agreed to cover the difference. Are you willing, or is the seller willing to pay 3%? I just want to make sure I let my buyer know, because whether or not they will be paying the difference. There's nothing wrong with that conversation. So if you get that call and you're offering out 2.5%, that buyer's agent's not doing anything wrong, unless they're making it sound like they're not going to show the house should you not offer more. That's illegal, right? But a lot of people are misunderstanding that phone call. A lot of listing agents right now, I'm getting some phone calls saying, hey, this person called me and said, you know, they're not going to show it unless they're offer 3%. And when we clarify, the buyer's agent saying, no, we're scheduled to show it. We're absolutely going to show it. However, we just wanted to let them know that if my buyer chooses this house, it will cost them a little bit more to purchase this house than it would the neighbor's house, is exactly the same, all things else considered. Now, on the flip side, as a buyer's agent, you don't have to hold your buyer to this. So if you have this in here and it comes down to 2 houses and you're looking at 2.5 for one, 3 of the other, you call the listing agent's not willing to pay more, not able to pay more, whatever it may be, which, by the way, if they say no, that is their right. That doesn't make them a bad person, right? You may say to the buyer, you know what, this house checks every box that you have. I'm not going to worry about the 0.5% difference here. Let's just get you moving forward on this house, and you can do that. Just as a little side note, as a buyer's agent, there are a lot of negotiations happening on the commission that is offered out in the MLS. So if you do call, I mean, we know a lot of agents that their standard of practice is to call and say, hey, I see you're offering out 2.5. Are you willing to offer 3? It can be a negotiation. This is not the whole negotiation, right?
Jacob, why would the selling agent or the listing agent agree to something like that?
Agree to pay to raise the percentage?
No, yeah. If they're listing it at 2.5, and you know the agent calls and says, "Oh, can you do 3?" Why would the agent do that?
They may not want to worry. They may not want to run the risk of losing that buyer. You know, that buyer may say, you know what, I do like the house, but I'm not going to pay more to be in that house. I'll go to another one.
That seems like bad business practice being in sales, personally.
Which part?
You're gonna owe more money if you go with the house on Main Street because you're gonna have to pay a 0.5% commission. Like, that seems like you'd kind of be shooting yourself in the foot for like referrals and long term. I think
as a buyer's agent?
Yeah, which is why I wouldn't even feel comfortable saying that. Like, just me personally, just complete side.
100%. So here's the deal on this discussion. And this is one thing that, you know, I've said from the beginning. I have, you know, my own personal business practice is I agree with you. My wife, Lynn, you all know Lynn. She's that way. I mean, she's always done, I'll pay out of the transaction. I 100% would support you should you say, I'm going to go with 3% though, right? Because what the other argument would be, I should say not argument. The other perspective of this would be, well, I feel that my worth is 3%. And so my buyers, because of the value I provide, my buyers won't have a problem paying that. And there are some buyers who will see that value in there and will pay the difference. So I should clarify that my example is not a good buyer presentation, right? It's just basically stating this ultimately is what it is. If this is the practice that you had, you would have a buyer consultation where when you got to this, you would say, and by the way, just one of the things that we do have in our buyer, as working with us is we do have a guarantee that we will make the 3% on here. And I tell you that and if you've done a good enough job on the buyer presentation, the perspective is the buyer won't have a problem with that. That's not to say your point's wrong, right? It's just a different way on how.
Yeah, that also protects you on for sale by owners though, much more.
It does. And the thing is on that one is the same rule applies though. At the end of the day, are you willing to hold to that if your buyer finds a for sale by owner that's their dream home, right? However, it still protects you to be the first point of contact. And in my opinion, it does put liability in the buyer's court to make sure that they keep you into that discussion. Because, the for sale by owner discussion is a different one because quite frankly, we have been in a handful enough situations with for sale by owners where we have been burned, where I would like that in there as a protection, not to say, hey, it's going to be me, my way or the highway. You don't get the house. No, I mean, we've walked away from for sale by owners because the for sale by owner absolutely refused to pay the difference. And it was a situation where the buyer didn't have the cash to close. They just did not. Well, I mean, our personal preference, we're not going to get in the way of that. However, going back to what Sarah was saying, it does protect you in that discussion at a minimum. So good points.
Well, so in that though, if it was a for sale by owner and if you did have option 2, would you do a transaction? How would you, and the seller who's unrepresented said, yeah, I'll pay you 3%. What form would you use for that? Or what would you do for that?
You would use a compensation agreement on that.
Okay.
Yep. You'd want a compensation agreement regardless, right? So if it was option 1 or option 2, you'd want the compensation. You would also, in that case, unless they wanted to be represented fully, which I would not in a for sale by owner situation, I do not feel that there is a situation where after you explain agency to a for sale by owner that you then should be representing them. A for sale by owner has clearly chosen they do not want to be represented. So they would be represented as a transaction broker. It's ultimately their decision. But if I were going out right now with a buyer and I had a for sale by owner, when I explained the agency to them, I would say you have 2 types of agency that are in here. And then you can be also represented as a customer. In this situation, you would be represented as a customer as you've chosen not to be represented by an agent. A little bit different when a buyer comes in on your listing, in my opinion. Okay. All right, so option 2 basically says I'm getting paid out of the compensation, right? So, I get paid a broker fee of whatever they're willing to pay, and that includes for sale by owner. For sale by owner decides they're not going to pay me anything, then that's the risk I take in this situation. Now, understand there is a difference between there is absolutely no correlation between compensation and representation. So if you opt for option 2, and you get to a for sale by owner situation, and for sale by owner says I'm not paying you, that doesn't automatically mean you no longer have representation of that buyer. So if you're choosing at that point to not represent the buyer in that transaction, you would want to get this agency agreement terminated because they are going to go through a transaction. And if you don't want to represent them, if y'all are going to come to an agreement to not represent them, you would want this terminated. Because if anything comes up on that transaction and you're still representing them, then you'd be held responsible for it. So just keep that in mind. All right, so the second part is going to be a retainer fee and a service fee. So buyer will pay broker the following. The first part is the retainer fee of blank, which is due and payable upon the signing of this contract. This fee shall or shall not be credited to the brokerage fee. This is basically saying, hey, you're going to pay me a fee, for example, $350. We would take that fee here in the beginning, and then when we close, that is either going to be applied towards the brokerage fee that we get, or it's in addition to the brokerage fee that we get. The second part is going to be a service fee. The buyer shall pay a service fee of blank to be paid on blank calendar days, whether or not the buyer purchases the property. This describes this. It gets a little confusing, so I'm going to go through it, so bear with me. So the service fee shall be the only fee due to the broker from the buyer under the terms of this contract. So this is saying I'm getting paid a service fee here. I'm not getting paid this as well as a brokerage fee. So this could be something that if you had a situation where you went in there paying you a service fee, you had a for sale by owner that wasn't paying you, you would use that. The service fee shall be credited against the brokerage fee described above and shall be kept by the broker whether or not the brokerage fee is earned. Okay, so again, you're going to get the service fee. It's going to be paid. It's not paid at signing of this, but it will be paid regardless of whether or not I actually get the brokerage fee. And then the last one is the service fee shall be credited against the brokerage fee described above and shall be kept by the broker whether or not the brokerage fee is earned unless the buyer enters into a purchase and sale agreement. In the event the buyer enters into a purchase and sale agreement, the buyer and broker agree that the above service fee will be credited against the brokerage fee in subsection above. So basically, a service fee is a fee that will be paid before they go under contract or if they don't go under contract. Okay. Whereas a retainer fee is basically an upfront fee that they're paying. Very few people do the service fee. There are a handful of people that will do a retainer fee. Actually, that's not true. People will do a service fee that will go in addition to the brokerage fee. Okay.
Joseph,
Yes.
I'm surprised that the real estate industry doesn't use this service fee a little more normally, because, I can spend a lot of times driving buyers all around, showing them houses, they're here. Oh, then they decide, oh, they're not moving to Charleston. They're going to move to Beaufort, or they're going to move wherever, or they decide that they're going to rent. And so
Right.
you used all this time, energy, all over town, and then they decide this. So it seems like the industry should be kind of looking at that.
I think we are going to see over the next few years a shift in how buyer's agents are going to be paid for a couple different reasons. One, like you just said, especially just have a service fee in general, particularly in a market like ours. You've got a lot of people that are shopping the coast.
Yeah.
Okay, that's fine. I'll help you do that. So I think that's an easy example to it. I think the other one that's really coming down the pike is the fact that the DOJ is really cracking down on how real estate commissions are advertised, not necessarily how they're paid. But if you think about it, you've got a situation where everyone's fee is paid by one party, and it's a large fee. Let's just go ahead and put it out there. We can say it's only a percentage all day long. It's a large percentage. The DOJ has ruled, and NAR is going to be announcing the rules probably, where they're going to be supporting it, where, actually technically now we can't advertise as buyer's agents that we work for free, at no cost to the buyer. Like, we can't say that. It is not of no cost to the buyer. The buyer's purchasing the home. So when they purchase the home, they're obviously going to be paying the fee, but they're getting pretty strict on that. Secondly, it is going to be required, and I think this is what starts maybe in June, that the buyer's agent fee is disclosed publicly on all sites, right? Anywhere that it's advertised. So it will be more general, more knowledge to the general public what the buyer's agent is being paid. And I think as more people start to understand that and see that, I do think there will be pressure for those payments. Again, this is a crystal ball prediction. For those payments to be separated and be paid by the parties with whom you have the fiduciary responsibility. We'll see though. People have been saying that for years too. So we'll see.
It seems like it balances out anyway, because on the buy side, you're not spending any money. You're buying the house, but it's not costing you. But on when you go to sell it, then it's going to cost you something. So it seems like,
but it's baked into the cake though. So it's like and that's kind of the NAR and the DOJ's point on this, is it is costing the buyer money. The buyer's not having an option to pay that. And how they're looking at it is the DOJ saying, we're not giving the option to the buyer whether or not they want to pay it. I mean, who's to say? I mean, and this is what's probably happening is lawsuits are coming up and they're saying, well, I mean, everybody keeps saying that my buyer's agent I was getting paid out of the transaction. I wasn't paying it. Well, had they not been involved and I could have gotten a $12,000 discount on the house, and I would have liked that option. And right now, how it's set up and how it's being advertised, a lot of buyers don't feel they have that option. So it'll be an interesting topic to follow. All right, section 7. This is where you talk about the consent to dual the 2 types of dual agency. Obviously, at this point, they'll check that you have explained dual agency to them in the agency disclosure, and then they have the option permission to act as dual, or they won't give permission to act as dual, and then permission to act as designated, or they won't give permission to act as designated.
I've always been curious of why this dual agency, designated agency, explaining the form ahead of time, then it's on again, A, B, and C, we're reiterating all that. Why is this so important that we have to talk about it first before we even talk about this in the agency relationship? Then we're bringing it up here again, and then we're bringing it up here again. I mean, why are they harping on that so much?
Because the number one, I would be willing to say, because I will tell you, the number one complaint that I hear from the consumers is they did not realize they were signing an agency agreement when they got involved in this. They did not realize they were signing something that obligated them to be represented by the buyer. Because what happens more often than not is these forms are not given to the actual buyer until they're filling out the entire contract. I can't tell you how many times that we get approached by buyers that will call on your sign and say, hey, I want to come look at your property. Are you working with an agent? No. They come to find out they actually did sign a buyer's agency agreement during all of this. And they're doing everything they can to protect the consumer, to make sure we're explaining to the consumer what the difference in representation is. So.
Okay, just seems like a little overkill.
It might be. It might be. All right, so going on to page 3, other potential buyers are disclosing that there are other potential buyers that have entered the similar agency agreement. And this is kind of the second time we're disclosing that. The buyer consents to broker representation of such other buyers and agrees not to give buyers confidential information to such other buyers, and not to give such buyers their confidential information to buyers unless otherwise agreed. This kind of takes it a little bit further in the multiple offer situation if you represented 2 buyers. The indemnification of the broker basically says the buyer promises to disclose to the broker whether the buyer has signed any other agency agreement with any other broker. This was brought up again to say, because obviously what would happen is, fast forward, goes down the road and says, well, Patty, you've been working with Sarah and I had an agency agreement with her. And Sarah was like, well, I had no idea I'd signed that, right? Well, Patty, that was your responsibility to figure it out. Well, maybe, but not really. This is basically saying that the buyer that has the obligation to disclose to us if they were currently had an agreement signed with someone else. The problem here isn't whether or not they're being honest with it. The problem most of the time is they had no idea what they signed because they were throwing together an offer at the last minute, a multiple offer situation. In the event the buyer wants to be held confident or anonymous, at this point they would have to tell whether or not you have permission to disclose the buyer's identity. So, this would tend to happen in two situations we're seeing it. Within neighborhood purchases, if you have a buyer that's purchasing another house in the neighborhood, they don't want the agent to know, or the seller to know who it is that's purchasing, because they feel that they either have bad blood or they know they have money or whatever it may be, or high net worth clients. A lot of times you'll get it with that.
Hey, so what name do you put on the contract or the offer?
You could do a couple of different things. You could have their lawyer say that there'll be a straw buyer on there. You could put a to be determined. Unfortunately, that doesn't really guarantee the contract. They, at that point, there would be a document you'd probably have to have drawn up from the attorney. We don't have it happen very often.
Okay.
All right, so brokers limited liability limitation. This is the one that really gets pushed back sometimes too. Basically says buyer agrees broker provided the buyer with benefits, services, assistance, and values by bringing about this contract. In consideration and recognition of the risk, rewards, compensation, and benefits arising from this transaction, the buyer agrees that he shall pay broker's attorney's fees and that the broker shall not be liable to the buyer in any amount exceeding the broker's compensation for reason of any act of omission, including negligence, misrepresentation, errors in omission, or breach of undertaking. basically what this is saying, I'm not going to continue to read through all of it, but this is basically giving the liability limitation that says, hey, if anything goes wrong in this and I got brought into this for something I didn't do, I'm only going to be responsible for attorney's fees or anything up to what the amount of my commission was, and then you would be responsible for the rest. In this market, this is the area where we're having a lot of them push back to say, no, I'm not going to be responsible for any of your attorney's fees or anything like that. That is something that really would not have anything to do with what I had to say or anything that I did, I being the buyer. So this would be one that, should you have a buyer push back on that, reach out to me on this. 9 times out of 10, it will be one where if they want to cross through this, that's fine. We've never really had a situation where we've gone after, I've never had a situation as a broker where we've gone after a client for attorney's fees, because most of this would, unless it was the only time we would, unless it was a frivolous lawsuit from client to broker, which we don't have. Section 12 says we will not discriminate. This one does need to be updated. It doesn't have all the protected classes on there, but it does, basically that we do follow federal fair housing regulations. If you do have any question, the broker is being retained solely as a real estate agent, not an attorney, tax advisor, lender, appraiser, inspector, anything like that. This right here, in my opinion, is a good place for you to say, listen, we're going to bring in, here's how you can word this differently than say, hey, I'm not responsible for anything. Don't do that. What I could say is I could sit down and say, Sarah, here's one of the things that I want to kind of share with you how this is going to look. We're going to bring in a lot of professional counsel throughout this transaction, right? As it states here, you've hired me to be your real estate agent. And where I'm not an attorney, tax advisor, lender, appraiser, I'm going to make sure that you have your selection of the best in those fields. You can choose whomever you'd like. Here are the people that I would recommend. And during this, I'm going to help facilitate the conversation with all of them. But I want you to make sure that you know that they're all going to be on your team and you're going to be basically having conversation individually with each one of those, because we want to make sure you're comfortable moving forward on this. To me, that is a great way to set Sarah up for A, confidence in the transaction, and B, it removes you from being the catch-all on everything. Now, I am saying this less about a liability issue and more about a comfort for the client issue. That being said, I will tell you numerous times where our agent has gotten into trouble is because that agent tried to be the expert in everything by relaying all the information. Well, here's what the inspector has said. Don't say that. Sarah, here's what the inspector's opinion is, and I'm going to put you in touch with them so you can ask questions about it. Here's what they said in an email, right? Or here's this. But you want to make sure, don't be afraid to put them in contact directly with them. I don't know if a lot of people are hesitant to do this because you want to be the center of the communication, or you feel because you are making a lot of this, you want to take work off of the buyer, and I appreciate all of that. And just understand that part of their process of purchasing a home is to be able to speak directly to these professionals. Okay. 14 talks about if you do get in a disagreement with me as your agent, we'll mediate instead of sue. We can, that honestly, I don't know that any mediation, I've been a part of any mediation between a buyer and a buyer's agent. Sex offender registry and criminal information, I am not allowed, because of how often it is updated and the accuracy of it, I'm not allowed to give this information to you. This is going to be the responsibility for you to find out online whether or not there are sex offenders in the area, and also the criminal information, statistics, et cetera, of the area. 16 is this is an entire binding agreement. It basically says it can only be changed by a subsequently written instrument signed by both parties. So this is, we can't unilaterally change this or anything like that. Any contingencies in here, this is if you did want to put in there, if at any time either party wanted to cancel, they may do so in writing. You can do that. That's how a lot of times people do it. So they make sure they have a longer agreement and say, listen, if you're uncomfortable, you can always cancel at any time. Section 18 talks about we can use fax machines and electronic means. And basically where it's more now is electronic signatures. It covers that. Surveillance warns them. That says that basically you're advised that the properties we enter may have both audio and video surveillance. The sellers are required by law to follow South Carolina law. I can't guarantee that's going to happen, but this is basically your blatant disclosure that you may be surveilled when we look at these properties. So let's make sure if you have any questions, any comments about the properties, we talk about them in the car or back at the office, not on the front porch. This is a legally binding agreement. If you do have any legal questions about it, you should consult an attorney. Buyer broker acknowledged receipt, a copy of these agreements and a copy of South Carolina disclosure of real estate. Again, Patty, it's your favorite part. We're once again talking about disclosure of South Carolina brokerage relationships. And receive communications from the broker at the information listed below. You know, we joke about it, Patty, but the bottom line is across the board. I mean, it's one of the first committees I got involved in years ago was grievance professional standards, and I don't think it's 90% of the problems that we see amongst agents in real estate is not ill will. It's just not. It's carelessness, right? And it's not carelessness. It's more of a you know, if it were you or me, it would be a careless because we're confident in what we're doing and we know that the process is this, and we want to make sure that this buyer gets the property, so we're going to move quickly. And what happened in that carelessness is they filled out a buyer's agency agreement. They're now working with an agent they had no idea they were. That's what tends to happen. And so that's why the state is so, like, the association is like, let's disclose as much as possible. I mean, this whole agency disclosure has always been a thing. There's always been an agency disclosure brochure in all 3 of the states that I've been licensed in from the beginning. It's what's funny is that's never changed. They just keep forcing us to make sure they tell us that we gave them that information throughout the entire process.
Right.
Yeah. Which isn't a bad thing, but it does seem to be a little bit of overkill. And quite honestly, I think if you've done it correctly, it's not as bad, because then when you get to that, you can simply say, Patty, you know, as we talked about earlier, the state wants to make sure that you are aware of this to protect you. This is just acknowledging that again. Boom, boom, boom. So,
But
all
it's
right, questions?
interesting if you say, like, you know, we explain the dual agency, the designated agency, all that, but yet you're explaining that and they don't realize that they're signing a contract with you as you're their agent as
Correct.
we go through this real estate procedure.
Yes. And I think that's,
Maybe
I
there
think
should
that,
be more of an emphasis on I'm your agent. And it's not the dual agency. It's not the designated agency or those kind of things. Because that's where the emphasis is put, in my opinion.
you know what? I think you're absolutely right. I think that's probably one of the issues, saying, hey, this is what happens if that were to happen. And it's kind of like, oh, by the way, by signing this, I'm your agent. No, so I think you're absolutely right on that, which is why it's one of the many reasons that you should have a buyer's agency agreement signed well before you're doing other documents.
Yeah.
So it doesn't get lost in the shuffle, which is what's happening.
Yeah.
So other questions? Celeste?
So one thing on the agency, when we actually do sign it, I tell folks that this is kind of like us being Facebook official, and everyone kind of gets
Ooh, yeah.
that. So that's a good one. I don't know that this is necessarily related to this. It kind of might be, but more of a disclosure question. I have a listing that is going to become available in the end of July. I do have a listing agreement for it. I have a buyer customer that reached out saying, hey, I might be, you know, this is kind of what I'm looking for. Will you just set me up on a drip campaign? They're looking for my listing. How, when, since we're not going on the market for a while, how do I do that and tell them, hey, I might have something that is going to be, it might be a good fit. So let's check it out.
Well, okay. So here I love clear cooperation. So the clear cooperation policy, as it's written in that situation, even if they were a client of yours and not just a customer, in that situation, it would be you could do one of two things. One, you could say, hey, 123 Main is coming on the market at 325. If you did that, you've triggered clear cooperation. You got to go to the MLS.
Mm-hmm.
Or you could say, and nobody's going to go on record of saying this, but I've spoken to a lot of people. So the next thing and how you would apply this clear cooperation is, I have a property that is going to be coming on the market June 1 that I do feel that would fit this criteria. However, I can't, you know, because it's not going on until June 1, I'll have to get back to you when it comes on the market with all the details on it.
Okay, that's fair. So just
you can do.
Okay.
Yeah. And if they push back, you can simply say, I mean, and again, this is This is a topic, but any other, I do want to come back to it. Any other questions about the buyer's agency agreement on this? Okay, so